Welcome to AI for Lawyers.
Hey everyone, welcome into an all-new episode of AI for Lawyers with attorney Samar, Shah, and Lawrence Liu. I am your host, Mike Leon. You know, Samar and Lawrence, they've been helping law firms use artificial intelligence safely and responsibly through secondopinion.law, which is a platform built to make smart automation simple and compliant. Today's episode, we're going to be talking about the ethics around AI, something I have spoken about as well. Samar and Lawrence are going to explain what the rules say, where the gray areas are, and how firms can build guardrails that actually work. Gentlemen, it's good to see you guys both. Happy New Year to you and yours. Lawrence, let me start with you on this first question. So attorneys come to you guys, they start asking about using AI. We know this is not maybe their area of expertise, but what are some of the top ethical concerns that come up that they bring up to you guys?
Hey, Mike, thanks for having us. I think the biggest concern from our views is the copy and paste today. A lot of people would copy and paste their documents and whatever they're working on into, public ChatGPT or Gamma AI. They don't know what's happening in the background. Do they keep track of those information? Do they use those for training? So that can be a big problem. So for attorneys or anybody who's using AI concerning about their privacy and their information, they should be very concerned about those applications or those online sites.
Yeah.
Okay, the other part is also about black box. AI is pretty much a black box right now. Even the open source one is a black box. You don't really know what's going to be the response and how it's going to respond. And even the same prompt you send it in, it'll come back differently every time you put it in. So those are the issues that people using AI should worry about.
It's a great point. And Samara, I want to piggyback on that. So when does AI actually require some type of disclosure to the client? What does that kind of look like in plain English?
Yeah, I'm going to talk a little bit about that, but I just want to piggyback off of Lauren's question for 1 second. When AI really started to be used by attorneys, there were, the stats were that they would find one hallucinated case a month. The stats are now that they find a few hallucinated cases a day, right? So it's a huge jump in terms of AI usage across attorneys. And hallucination is a big ethical concern, right? A lot of attorneys are getting sanctioned, and some of them are getting disbarred by courts and by bar associations for using AI or hallucinated case law. It's a bit of a wild west out there. And I'll just add one last thing here. You know, one of the big promises of AI has been that attorneys can be more efficient, right? And this is a big ethical concern that really no one is talking about right now, but will be huge in the future. Is that the latest surveys show that only 6% of attorneys are charging less after using AI, right? So attorneys are using AI left and right, and the clients are getting the same bills or even often, right? So it hasn't translated into efficiencies for the clients. And that's a big problem because there are a lot of bar associations around the country that say, hey, if you don't spend time on a case, if you use tools to be more efficient, you can't charge the client for that time anymore, right? So that's something a lot of attorneys should be thinking about and putting on their radar for sure. The disclosure, the rules are actually all over the place right now. There are some bar associations that require attorneys to make disclosures to their client. They're very strict. So, Pennsylvania and West Virginia are two of the strictest states when it comes to this, where you have to disclose to the client that you're using AI. And if you are even using it to streamline your case process in the back end, right, for your administrator, you still have to disclose that. There are other states like the New York Bar Association, which are much more permissive. And they say you don't have to make any disclosures whatsoever, right? So you can use AI. You can even theoretically put in confidential client information into an AI tool and deliver legal services without having to make any disclosures to the client. Now, I wouldn't recommend that to any of the lawyers listening, but that's where it is. There's a huge disparity in terms of what is permitted from a disclosure perspective to the client.
Yeah, I wouldn't do that either. I wouldn't advise that. As the son of an engineer, I would not. Let me ask you, Lawrence. Then I guess it funnels into a follow up of like, how can lawyers protect this privilege and confidential information, especially when they're experimenting so much with some of these cloud based AI tools?
I think, like I said earlier, right? It's important to know the difference between enterprise and consumer AI, right, or API that the company is using. So for the consumer, anything is possible, and sometimes they're free. So assuming free, the company have to make money somehow. So they need to use your data for training or for other purposes. So company need to understand that they need to use enterprise and strict regulation and strict policy and strict agreement that they agree with the vendors and with the back end vendors for their use. So that's important. The other part is they need to know where their AI companies running their data centers. It could be in the US, could be in Europe, could be in the Middle East. So that's something that they need to be aware of, just where their vendors are running their AI inferencing.
I think that's a great answer. I'll add one additional data point here that some attorneys may not be thinking about, and they should be. A lot of attorneys are using AI tools to transcribe meetings between themselves and their clients for note-taking purposes. And there have been a couple of cases now where the courts have said that having a free AI transcribing tool, which took this transcript, right, that made it available to people at the company, was disclosure or misappropriation of trade secrets. So if you're talking about very confidential trade secret type of things with your clients, don't use AI transcription tools, right? That could potentially expose client confidential information. So you got to be very careful, not just with traditional AI tools that Lawrence was talking about, but also with transcription tools and other things that are kind of creeping into attorneys' workflows every day.
That's right. Don't click on that blue approve icon. Click on the decline button on the Otter AI. Anyway, so let me ask you then, Samar, on that front. Why don't you walk us inside, like, for partners that are supervising associates who have used AI? Like, what does that reasonable supervision look like in practice for them?
Yeah, and I think this is where there's going to be a big shift in how attorneys practice. The traditional model is you give your junior attorney a task, right? They do it, they send it to you, you mark it up, you have a conversation with them, be like, what did you search? Why did you do this? What's the case law say? And then you educate the junior attorney that way, and you can also verify the accuracy of the work product that they're putting together. With AI, it's not like that, right? There's nobody to talk to. It's a black box, like Lauren said. It's giving you output. It could be right, it could be wrong. And even if you assign a junior attorney something to do, and if the junior attorney uses AI, that's potentially a problem, right? Because it's not verifiable. So to me, what needs to happen in law firms in the future is having some pre-training of attorneys where you set up guidelines on how to use AI, you tell them where the pitfalls are, you educate them, you let them play around with it in a sandbox kind of a case where they can explore the limits of these AI tools. And then you have to have a policy internally where everything that the AI says has to be verified by a licensed attorney, right? Like there's just no way around that. So you can have AI do some drafting and create efficiencies, but everything it generates has to be reviewed by an attorney. And then I think you need to have some kind of additional, verification policy for that as well, both in terms of the facts and the law. And then you need to have an auditing process where you can, there are cases where a practice manager at a law firm was fined and sanctioned, even though he didn't personally do any of the work, in charge of the whole practice. And if attorneys in that practice were using AI and submitting hallucinated cases, the management could be responsible as well. So you need to have good audit proceedings in place as well for attorneys to deploy AI successfully in their firms.
So, Lawrence, I want to ask you, because you mentioned before about data storage and making sure you know all this before you sign a contract. So, what are some of the due diligence questions that firms should be asking these third-party vendors about? Like, what is there a checklist that you would advise them to comprise before they sign that contract?
Yeah, there definitely be a list, at least about data training. Ask them if they're using my data for training? If the answer is yes, then the meeting's over, right? Asking, like I said earlier, where is it they're running their machine, their systems? Is it in the US? Is it in Europe? Is it in the Middle East? So those are important. And then are they using a wrapper? Are they using a wrapper around OpenAI or Anthropic, or they have their own AI models? So those are the key questions. And then also, are they keeping track of the logs and the version control? And are they able to reproduce their results? Can they generate it once, and the second time, is it pretty close or something totally different? So those are the things that are very important when you use these kind of tools, because unless your system is set up for them, you're not going to get the right result.
It's great points. I hope lawyers listening out there are writing this stuff down. Samar, I want to go back to something you said before about lawyers are still charging the same amount, yeah, or at least less than 6% or something like that. So as AI is shortening the drafting, the research time that these firms are doing, how would you advise the firm stay transparent about the fees? What should they be doing about that?
Yeah, different jurisdictions are going to have different guidelines about these things. So definitely check with your jurisdiction and your state bar offices. Everybody's promulgating guidelines and rules about what to do in these cases. But there's one instance from Florida, right, where where they issued an opinion that said that, let's say you are generating a memo for a client on a particular case, and then a second client comes along and they want a memo on basically the same case. Are you allowed to bill both clients the same amount of time? Even though you didn't spend the same amount of time on the second memo. And the answer is, of course, no, right? You can't bill the second client the same amount. You have to bill them for the time that you actually spent in adapting the memo to that client, not rewriting it from scratch. And the same kind of logic would apply to AI cases, right? So if you are using AI to help you be more efficient in your drafting or in your research, that needs to be passed on to the clients under at least the guidelines promulgated by the Florida Bar Association. Of course, the statistic that I mentioned earlier, in-house counsel are reporting only a 6% of their invoices are showing a drop. So we know that attorneys are using AI, right? 70% of all attorneys are using AI is the latest statistics. And if only 6% of them are reducing their bills, then we know that at least some attorneys are probably running into problems with regards to billing. There hasn't been a lot of case law around this, right? It hasn't gone to an ethics board yet, but it will soon. And you got to be careful that if you're using AI to be more efficient, you should be passing those costs on to the clients. There are some attorneys listening here who probably do contingency work or flat fee value-based billing work. That's a bit of a gray area as of right now, but at least some states have stated that, even if you're doing, contingency work, that contingency fee should reflect the work that you're doing, right? So if you're charging 30% contingency fee, and with pre-AI, right? But post-AI, let's say you're doing 10% of the work because AI is doing the other 90%, then your contingency fee should drop accordingly as well. So that's something to be thinking about, even if you're on a flat fee model.
Lawrence, let me ask you about something that Samar said about in terms of being careful. And I translate that to compliance, right? So, what would be the best way you would advise firms to document their AI use so that way they can show compliance in case questions do arise?
I think it's important that you have audit logs for everything. That's what we build when we build software for enterprise. We have audit and log for everything, including changes, minor changes. Anything that touches our software will be audit log, and we log everything, every bit of it going through our system. So there's a way to get back to it, even though it can be years from now. So that's one thing. The other thing is we want to make sure we keep track of the models that we use. So different models generate different response. We track all of that also. So even though they keep changing to a new model, more advanced models, we still keep track of that, and we can go back to the older models if we need to reproduce it. So those are the key things that we keep track of.
In addition, I would say make sure you look at your engagement agreements, client engagement letters. If you haven't dusted those off in a while, you should, and talk about AI usage and policies. If you're using AI, make sure you're reading those, policies and statements and what disclosure requirements are there. So you need to kind of clean up those two things as well.
Well, Samar, and it funnels into the follow up, excuse me, beautifully as we put a bow on this episode, which is what advice would you give, especially as these ethics rules start to evolve over time? What advice would you give, habits that should be created by these lawyers so that they're getting ahead of the future AI guidance from bar associations?
Yeah, I think certainly you should have some training set up, right, for attorneys to use AI so that everyone is using it responsibly and ethically. I think most firms would benefit from having some kind of an AI governance board or committee, right, within the firm that would allow them to, figure out all this stuff and talk about how to create a regular audits of the AI work product, how to train associates and partners in terms of reviewing AI output for factual and legal accuracy. Having that kind of stuff will go a long way in terms of shielding the management, at least, from ethics concerns and sanctions and things like that. And then you also need to have updated client communication around AI usage, right? You need to tell them probably what you're using AI for, what kind of information is being put in there, how are they protected, and if something happens, you certainly need to communicate that. So having those two bodies, and it could be the same body, it could be one person at the firm who's in charge of understanding AI usage within the firm, training and auditing, and then also communicating with the clients about usage so that everybody's on the same page.
Yeah, great
I
points.
want to add to that. One more thing, in software they should have human in the loop architecture, so that always makes sure at the last stop, always somebody have to verify it and check it off and say, okay, this is good. This can be go through, because more and more of AI architecture, they're using agents. So agent will perform tasks on their own and then execute those. That can be very problematic, especially if you don't have the architecture that will have somebody verify it before it sent out or before it getting processed. So that's something that they should be aware of, because the trend of AI is moving to more automation with AI agents, and things can go wrong very quickly.
Yeah, and I'll add, and Lawrence is too humble to brag about this, but he's built and architected this module in Second Opinion, our software product that allows attorneys, where the thought process of the AI is documented, right, as it's reviewing documents and generating additional parts or clauses of an agreement, which makes it super easy for a supervising attorney to understand the logic that the junior associate was using, or if there are multiple attorneys on the case, everybody can read not just the output, but also the logic that was used by the person who was using AI. And it was a feature that was built with the attorney in mind, right? Like there's no one who can benefit from an audit log or just a review of not just the output, but also the logic that the AI uses than attorneys.
Yeah.
And it will help
Yeah.
prevent a lot of these problems that we're seeing today in bar sanctions and things like that.
Yeah, it's great points. Gents, we end the conversation there. Thank you so much for the time, the insights. I appreciate it, guys.
All right. Thank you, Mike.
Absolutely. Thank you.
And thank you to everyone out there for listening to this installment of AI for Lawyers. If you want to download practical templates for AI disclosures and supervision checklists, do me a favor right now, visit secondopinion.law. Thank you to everyone again for listening. But before you go, do me a favor, hit like, hit subscribe, leave us a comment and review, or share somebody who's about to start incorporating AI into their everyday workflow. As always, I am Mike Leon. See everybody next time.
Thanks for watching. Be sure to hit that like and subscribe button and leave us a review in the comments.